Brenda Agnew, and I'm with an organization called 3 to Be. 3 to Be is a foundation that raises money for children living with neurological disorders and their families in the areas of education, research, and therapies. I am the director of our parent advocacy link. Today we are going to be talking about demystifying the legal process. And joining me are Neil, partner with Howie Saxon Henry, and Megan, an associate with Howie Saxon Henry. Okay, so the family has, they've had this inkling in their mind, they've made a phone call, they've had this conversation, maybe some preliminary investigation has happened. And from that, it's sort of pointing towards them potentially having a case. I would think that now they have a decision to make.
And that's exactly right. There's still a decision to be made. With the preliminary investigation, often we've looked into the liability situation. Was somebody at fault for what happened? Did somebody's negligence cause what's going on now? And you can decide to pursue it, or you can decide not to. So there's a number of things that you can consider when you're making that decision. Part of it are the risks, the fact that things may change over time, that opinions may change over time, depending on new information that comes to light. But another really important aspect is, what is it you're going to get out of this? What are you pursuing?
Right.
In Ontario, you can pursue damages for pain and suffering. Not only for your child, but under the Family Law Act, family members can also pursue losses for loss of care, guidance, and companionship. But think about the care needs that your child will have, the treatment needs that they have. Think about the additional medical expenses that you may be on the hook for. Who's going to provide the care for your child? How will they be paid? What does your family life look like? Do you as a parent leave your workplace? Do you lose income? You can pursue that. So all of these things together are what you would be pursuing in a lawsuit. And they usually add up to be a significant amount that you would be on the hook for, that you would be responsible for funding throughout your child's life. And those are exactly the things that we need to try to help put together or assess or quantify to pursue those for you in order to ensure that your child's and frankly your family's needs are met. And we do that in a number of ways. Mostly by consulting various experts who have experience in the field and can look at your particular family, your particular child, their particular needs, and determine what the future holds in terms of the care associated with that, and of course the cost associated with that. So there's a number of experts that would have to weigh in different fields to be able to give us that information.
Right, okay. So, that's a lot of information for somebody to sort of wade through. A lot of experts coming in and out, and a lot of visits, and a lot of things for them to sort of get to that point for that assessment piece. I've got to think that you've got to make sure there's good communication between yourself and your clients. There's a lot for them to absorb. And we're going to talk a little bit later about getting into sort of the nuts and bolts of the legal process, but, what should a client be expecting as far as that communication piece?
In terms of the communication, it really is, again, family by family, or our client, each one's different. This is, of course, an overwhelming sometimes experience for a family or for parents, and sometimes they prefer to sort of work on the home front and leave all of the legal issues and the steps in the lawsuit to us. Others want to be very involved.
Right.
We're really building trust where trust has been broken to a large extent. And so there is a great flexibility on our part to respond to the desire of the family or the parent in terms of how involved they want to be. And so that communication is very important. And it really is done or adjusted on a case-by-case basis.
We talked about communication and how important that is and how vital that is to the process, and the involvement of parents and how much they want to be involved. And we're sort of jumping into a big step here with discovery. I have to imagine that that's a huge piece of this moving forward. Can you talk a little bit about what that looks like?
That's right, Brenda. The examinations for discovery are one of the most important parts of the legal process. And the parents are very involved at that stage. An examination for discovery is a questioning under oath by lawyers for the opposing parties, namely lawyers for the doctors or the hospital that's involved. And typically the parents will be discovered. They'll undergo this questioning. And it could amount to a whole day of questioning for one of the parents. And then maybe not quite as much, maybe a half a day or less for the other parent. But it's a very important stage. The answers are very important to the process. And there would be a fair bit of preparation that we would engage in with the parents to be ready for that process. So we would meet with the parents beforehand, even a couple of times or more if necessary, just to go through what the areas of questioning is going to be and the process, how it works and how to answer questions, just to be prepared and to do as well as possible in that process. The questioning will generally cover the medical history, the history of the pregnancy, all the events that occurred in the hospital and afterwards. And those questions are geared towards the issues of liability, of the nature of the care, the quality of the care that was provided. But then there will be another whole body of questioning relating to the nature of the injury and the condition that the child has sustained. So there will be a lot of questioning about the course that the child has had, the treatment, the therapies, going through a day in the life of the child and the family, and basically all aspects of life are pretty much open for questioning through this process.
So I imagine that could be a little bit emotional and
it can
tough
be. It can be.
for some of those
It can
families.
be a very emotional stage, and with proper preparation, it can be done smoothly, as painlessly as possible.
Great.
But it is important, and both parents are usually quite involved.
So then I'm thinking you come out of discovery, you've talked about how both sides have, had this conversation, and there's got to be some information that comes out of discovery that you'll need to follow up on. Does that lead you into another assessment piece with respect to what the defense has presented, or what kind of comes after discovery?
Well, in addition to the discovery of the parents, there's also a discovery done of the defendants, the opposing parties, the doctors, and representatives of the hospital, and any nurses who are involved in the case. So all the information that comes out of these discoveries is considered by our experts. It's all transcribed and put into transcripts and considered by our experts. We then work with our experts in a further stage of investigating and analyzing the issues of liability and causation and whether there was medical negligence and did it cause the condition and the injuries. So we go through all that process. And the parents don't need to be involved really at all in that process. That's between the lawyers, between us and the experts that we're using. But then there will typically be some further assessments that start to occur relating to the injury and the compensation at issue. That's called the damages aspect of the case. And there will be a variety of assessments that take place of the child. Examinations with various medical specialists that are appropriate for the nature of the disorder. And these assessments we arrange to be done for our purposes by experts that we've chosen, but the opposing side also has the right to their own assessments with equivalent specialists of their choosing. So there are quite a number of assessments that have to be done, and that can be a difficult process to go through, but we try to make it as painless as possible again.
So I imagine a number of assessments in the home, outside of the home, so that's where you're going to need to sort of have that participation from the family in order to get this information that you require so that you can put all these pieces together.
That's correct. The family is involved in going to assessments with their child outside of the home, and there will also be some very intensive investigations or assessments done in the home with either occupational therapists or nurses or life care planners who come into the home to do an assessment of the child's need and the child's living environment, and the parents are very involved in that process.
Great. So they've come out of discovery now, and you've done some of these assessments. You exchange all your information back and forth. Where does that lead to next?
The next stage is usually mediation phase. Mediation is mandatory in cases brought in Toronto and some other jurisdictions in Ontario. Other places it's voluntary. When we're talking about these steps, though, I think it's important to remember that all of the information that we're sharing right now sounds quite overwhelming. If you had to do all these steps in a month or in a number of months, it sounds like a lot. It's a huge imposition on a life that's already changing and adapting to these new circumstances. One thing that I should mention is that these cases take years for a number of reasons: to collect the documents, to get the expert reports, to get responding reports, and then responding reports. And to see how the child grows and develops. That alone takes time to see how they're responding to different treatment and things. So the mediation phase happens after discovery, but not right after. And it is an opportunity where the parties, the plaintiff side, so the side of the child, and the defense side get together with a neutral mediator who they've both chosen to see if the case can be resolved at that stage. And it is a without prejudice discussion, meaning it's not carried forward in terms of any information that's shared. It is not something you can talk about after that. It's confidential. But it is an opportunity for both sides to discuss the strengths and the weaknesses in their case and see if there is a way that the case can be resolved outside of a formal trial setting. It's not the only opportunity, but it certainly is a very good opportunity for the parties to come to the table equipped with their understanding of the case, the value of the case, and to start actually talking about that. And I've found the need to ensure that people understand that that process, and the process in general, is about money. That's all that we can do, is get compensation for the needs that this child and their family has. It sounds kind of crass sometimes to say, what's it worth? That's exactly what you're doing at a mediation. But again, when you think about the purpose of that money, to provide for the future of this child and their family, that's the motivation. So the mediation is a time when you talk dollars. What is the value? What are the needs? What will assist in raising this child and in providing for them?
So ideally, a resolution happens at mediation. Doesn't always happen. If it doesn't happen, where do you go from there?
Well, the next step in the process is the pretrial conference. And that is a mandatory step that takes place with a judge. It's an informal meeting with a judge, and this is a judge who will not be the trial judge. If there is a trial later on, it would have to be with a different judge. But the pretrial judge will meet with the lawyers for both sides after receiving written briefs in advance from each side, and talk about two general areas. Firstly, planning for a trial to sort of discuss the logistics and the time required and the number of witnesses and all these practical matters for a trial. And then secondly, the judge will discuss whether there is any possibility for settlement and talk to the parties about whether there is a possibility to negotiate something with that judge's assistance. And there will be an attempt to work through that, and if it's possible to make some headway towards a settlement, that can sometimes be done at the pretrial conference, and it can be an effective way to do it.
Now, if no settlement comes out of pretrial, I assume you're going to trial.
Well, maybe. You might be going to trial, but there are still other opportunities to negotiate settlement right up until the time of trial. And settlements can even be negotiated after a trial has commenced, midway through a trial. But if a settlement does not occur at any of these points, then there will be a trial. Cases of this type are generally tried before a judge without a jury. But a few, are tried before a jury. It depends on whether one or the other side has chosen to have a jury. Either side can choose a jury, and that's usually done very early on in the process. That choice is made at the early stages. Cases that involve these complicated medical issues and long-term care issues and profound injuries will take a fair bit of court time to be tried. So typically, if a full trial needs to be done, it's going to be in the range of 4 to 6 to 8 weeks of court time, and that is a lengthy time. And the parents must be involved, obviously, at that stage, and it is a difficult process to go through for the family. But again, with proper preparation, and there will be a lot of preparation with the parents, with the family, all family members before the trial. With proper preparation, it can be made easier. So the parents should expect to be very involved with the lawyers during the months leading up to the trial and through the trial process. At the trial, the parents will testify, similar to what was done at the examinations for discovery, but this time in a more formal setting, in front of a judge in a courtroom, in a even more structured way. And parents could be on the witness stand for literally days, at least a day at a minimum, and usually multiple days. And then all the other experts will be called to testify, and other relevant witnesses will be called to testify. And the parents typically will stay and be present in the courtroom to observe and to watch everything unfolding.
Right. And what happens at the end of the trial?
Well, if the trial was before a jury, then there will be a verdict very quickly, relatively quickly after the end of the evidence. If the trial is before a judge will typically reserve judgment. That means they will take time to decide the case. And that could be a number of months that you'll be waiting to get the judge's decision in writing. In cases like this, it is very common for there to be an appeal by one side or the other after receiving the judge's decision. The losing party often appeals in this type of a case, and that will take another, usually up to 2 years, maybe even a little more, to be resolved. The case goes to a higher level court called the Court of Appeal. There's no witnesses, generally speaking, at that level. It's just a legal argument based on the transcripts from the trial, and the parents and the family are really not involved at all at that stage. It's all just lawyer work at that stage. And then there will be a decision from the Court of Appeal. Again, it could be a reserved decision that you have to wait for a few months also. Okay. And that's usually the end of the process. Further appeal to the Supreme Court of Canada is rare. It's only in very narrow circumstances that can be done.
So we've had a number of questions that have come in throughout our discussion today. We're going to go ahead and start with some of those questions. So the first one that I have, I'm going to direct towards you, Neil. And the question that's come in is, how do the legal fees work?
Well, generally parents do not have to pay legal fees along the way as we're pursuing the case. And the legal fees are in the form of a contingency fee. The fees come out of the settlement or the verdict. But it's important to know that in any settlement or verdict that relates to a claim by a child, the legal fees must be approved by the court.
Okay.
So there is a added protection in that way for the child that the legal fees charged by the lawyers are fair and reasonable.
Megan, I'm going to give you this question. One that's come in here is from a parent that says, I've already had to tell my story at discovery. Do I have to do it again for mediation and pretrial?
That's a really good question, actually. A lot of people ask that. The discovery is an opportunity, as we said, to sort of share your story, to answer the questions. The mediation is an opportunity for your lawyer to be your mouthpiece, really, to argue your case, to present the strengths of your case, and to respond to the strengths or perceived strengths on the other side. So it's more your lawyer engaging. Usually our clients don't speak at a mediation, but if you feel moved to, if you'd really like to, if there's something you want to add, certainly there's no rule against that. Same with a pretrial. Unless a judge directly asks you a question, which is unusual, and usually your lawyer can do that for you, there's no need to speak at either of those two events.
Oh, okay, great. I'm going to give you another one, Megan. One of the questions again that's come in is, am I allowed to read all of the assessment and expert reports?
Again, this goes back to the involvement that the parent wants to have. They maybe want to be involved in every single step, or they may want to have a really hands-off approach. Certainly they're entitled to review the reports. It does actually help them to be informed. It helps them to understand where we're coming from when we give them advice. And it just better, frankly, educates them on what their child is going through and what the experts are saying about their needs and things. So by all means, they're absolutely entitled to the reports that we get and the reports that the defense gets.
All right, Neil, back to you. Can we stop this process at any time?
Generally speaking, yes. If we as lawyers feel at some point that the case is not winnable for some reason, if there's been some radical change in the circumstances or the evidence that's coming out, we may even advise that it's not reasonable to proceed. And generally speaking, the case can be stopped at that point. There has to be a bit of negotiation with the other side to ensure that there's no costs that need to change hands at that point, but it's usually able to be done successfully in litigation of this kind. Right. That's generally true short of a trial. Once a trial starts, there may be other more serious considerations relating to costs that have to be addressed, though.
Great. So we only have time for one more question, but we're going to try to answer all of the questions offline that have come in through the discussion today. So the last question is going to go your way, Neil, and it is, if I do enter into a settlement, how does that work?
Well, that kind of dovetails with one of the previous questions, where I mentioned that a settlement of a claim for a minor requires court approval. So a judge has to be presented with the settlement proposal that's been reached and has to agree that it's reasonable for the child and in the child's best interests, and then it will be approved. And along with that, the legal fees must be approved and considered to be reasonable and fair. I should mention that in a settlement, one additional part of a settlement is usually a reimbursement of all the expenses or the disbursements associated with the litigation. Those are all the costs and out-of-pocket expenses that the lawyers have had to pay, that we generally pay ourselves for the expert fees, for transcripts, for all the records, for all the materials that have to be produced for purposes of the case. And we as a law firm generally pay those disbursements along the way because it is a lot of money and usually beyond the means of most families. Sure. We recoup that from the other side as part of the settlement. It's in addition to the settlement amount at the conclusion.
So I have a question on my own, and I'm just wondering, how do you help families through this process?
The important thing I think about our firm is that we pride ourselves on having a good balance. We're litigators. We fight, we go to trial if necessary. We're also good negotiators. But I think one of the most important things is that we have very good and close relationships with our clients. these cases can go on for years. And the communication, like we said before, is just so important. We have a very well-trained staff that speak to clients on a day-to-day basis. A lot of the issues in these cases, the reason that we don't have juries in a lot of these cases is because they are very complicated matters from a medical or scientific standpoint, but they're also very emotional issues because they go to the heart of the family or of the loved ones. And so we're able to relate on that level as well. So I think really having that balance between being the bulldog and also being the compassionate listener or the person that's going to walk with you on this, on this process is something that we really pride ourselves in doing. And it's a service that we're able to give to our clients that I think, ends up with the best possible result, ends up with people who understand and are satisfied with the process at the end of the day.
That's all the time we have for today. If we didn't get to any of your questions today, we will certainly make sure that we answer all of those offline. I want to take this time to thank Neil and Megan for joining us for this conversation.
Thanks, Brenda. It's our pleasure.
Thank you. And thank you to everybody, and we will see you next time.